All right, welcome back. We are in court starting today. We got a trial term going and a plea term. So a lot going on in Horry. We got court in Georgetown, and I'll catch you up to date on all of that stuff next week, whatever significant pleas come out or trials. We'll talk about that next week. This past week we had something of great importance to us that came back. The Court of Appeals upheld Sidney and Tammy Moorer's conviction. That's in the Heather Elvis case. She went missing in December of 2013, so it's been coming up on 10 years. But as I've told you before, as soon as you get a conviction in a trial, everybody gets a stack of paper and pens and they start appealing. And if a lawyer won't do it for them, they do pro se appeals. And in this case, they had a court-appointed lawyer that represented them in the appellate process. Their main concerns, as stated in their appeals, trying to get a new trial, was that the judge should have directed the verdict. The Court of Appeals said no, there was more than enough substantial circumstantial evidence to uphold the convictions for kidnapping and conspiracy to kidnap. They were complaining that the judge had kept some of the alibi witnesses from testifying. So what that is about is there's rules, and we've got to turn over everything that we've got that is exculpatory or that makes it less likely that they did it. We've got to turn over basically all of our file to them, and we did, and there was thousands and thousands of documents and computer printouts on that case. We turned all of that over. A couple of things that the defense by rule has to turn over, and one of those is alibi witnesses. So if you're going to say I wasn't there or whatever, and you're going to use a witness to do that, you've got to give the state 10 days before the trial, and they didn't give that. So the judge made the ruling that you didn't comply with that law, and he said, I can't allow those people to testify. It really, they wouldn't have been able to testify anyway, because on a defense motion, and this is the third area of appeal, on the defense's motion, the defense said, we don't want any of the witnesses in the courtroom. We don't want them to be monitoring what's being said. We don't want the state witnesses to listen to the witness before them and then affect or try to get their stories together. So the judge granted what's called sequestration, but he granted it for both sides. So there was a live feed going on, and when one of the sheriff's deputies went to take one witness and bring in the next witness, the sheriff's deputy saw several of the people that would later be called as defense witnesses sitting in there watching the live feed, and she told the judge about it, and the judge called him in and questioned him over that and said, okay, because you violated the sequestration motion, you can't testify. The same thing happened to us 2 weeks ago. In our case, we had a series of, I think it was 3, maybe 4 guys being charged with murder, and we were doing the trial, and some of our witnesses came into the courtroom that were boyfriend or girlfriends with the co-defendants that were testifying. And the judge said, okay, you knew the rules. Well, it wasn't anything on our part. We didn't know there were crowded courtrooms, so we didn't know they were in there. But anyway, it doesn't really matter whose fault it is. It's sort of a hardline rule. You cannot be in there, or you can't be watching it. So the Court of Appeals upheld all of that and said, no, you got a fair trial. You didn't get and the fourth thing was that they tried to say that the experts' testimony shouldn't have been allowed in. And if you remember back to that case, a guy named Grant Fredericks that teaches at the FBI come in and said, I believe to a reasonable degree of certainty that that truck belongs to the Moores, and it's the same truck that was seen going as was seen coming back, and it was captured off footage. There's a lot of science that goes along with that. When you put up an expert witness, it's got to be outside the common knowledge of lay people. In other words, I wouldn't be allowed to be an expert, even if I were a meteorologist, just come in and say it was hot. Everybody knows it's hot, or if it's not hot. But meteorologists would have special knowledge of how storms form and would be able to testify to that. It is not in the immediate mindset of people. And the defense had an expert that reviewed everything that Grant Fredericks had reviewed, and early on he said, yeah, that is a science, and Grant is the best at what he does. I would have come to a different conclusion. So the Court of Appeals said, that's fine too. That is to be laid out. It's a really good opinion for the state. I may have been skipping over some issues. I believe that was the major ones that they had appealed. And anyway, it's really good news. A ton of work went into that. It was really the Murdoch case before there was a Murdoch case. It captured the national media attention and the nation's attention for a while, and there's still family members, Debbie and Terry, that are struggling to this day. But you take the good where you can get it, and those appeals have been upheld. So the Court of Appeals said they got a fair trial. The next step will be they will ask the Supreme Court to hear and overrule the trial court and overrule the Court of Appeals. Supreme Court may, or the Supreme Court could say, the Supreme Court is unlike any other court except the U.S. Supreme Court. And they've got something called certiorari, where you say, I don't want to hear that. There's no new law that we can benefit the readers from. So they may not hear it. They only hear a portion of the cases that come to them. But we'll see. That'll be the next step. They'll ask for a writ of certiorari and ask the Supreme Court to overview Court of Appeals. And there will be appeals that come after that through post-conviction relief, which is a set of appeals. And then finally, when all of that is exhausted, I'm sure they will go to the federal courts and start the appellate process there. So there's always you always ask me, why is there any pleas? If you can work out a plea, it's always easier because there's really no appeals, or very few appeals that come along with pleas. But every time you try a case, people will appeal every jot and tittle that goes on in the case. So that was good news. I hope you are having a wonderful start to your summer, and we will see you next Monday with updates on what went on in Horry and Georgetown.